Hello. In this short video, I am going to cover the topics of suspicious activity reports, commonly known as SARs, the criminal offense of tipping off, and the so-called litigation exception to tipping off. If you work in Guernsey's regulated sector, and for today's purposes I will talk about financial services specifically, these terms will hopefully be familiar to you. I'm here to talk about the best way to navigate the SAR regime when litigation has been threatened or a claim has been filed. When the states of Guernsey developed its SAR regime, they included in Guernsey's proceeds of crime law an exception to the offense of tipping off, where a disclosure is made, 1, in contemplation of or in connection with legal proceedings, and 2, for the purposes of those proceedings. This is a departure from the UK system, where there is no litigation exception in the English Proceeds of Crime Act. There is nevertheless recognition by the UK government that regulated entities might find themselves in difficulty, where, for example, they have competing obligations under the civil procedure rules to disclose documents and information relevant to a claim or defense, but where that required disclosure potentially exposes them to criminal liability. The UK government recently issued some guidance on the point in the form of Circular 4 of 2021. Although the Guernsey law and the UK Act treat references to SARs in the context of litigation differently, and Guernsey financial services firms do not need to worry about tipping off in litigation in the way their UK counterparts do, the guidance given in Circular 4 of 2021 is nevertheless a useful reference in Guernsey in terms of best practices in litigation when a SAR might feature. These best practices are as follows. First, involve FIS as early in the litigation process as possible, as soon as it becomes clear that the fact that a SAR was filed is likely to become an issue in the case. This will generally mean at the point litigation is threatened, or, to think of it another way, the point at which you would want to notify your insurers of a potential claim. Second, having put FIS on notice that a SAR is potentially disclosable, assess whether it is necessary to disclose the SAR at all. The answer to this question will depend upon the facts of the case, and you will need to take legal advice on the point. Third, once you have established that a SAR will be a necessary element of the case, you should provide as much information about the proceedings as possible to FIS, including which SAR or SARs will be disclosable, a summary of the claims and defenses, the reason why, in light of the claims and defenses, the SAR will be disclosable, relevant court deadlines, and any other relevant material. When you provide this information to FIS, you are not asking FIS for consent, clearance, or permission to refer to the SAR. You do not need to do that in Guernsey, thanks to a more enlightened proceeds of crime law. However, involving FIS early and, if it becomes necessary, extensively, will A, maintain the spirit of the SAR regime in which regulated entities have a role to play in combating financial crime on the island, and more importantly, B, maintain, as between your organization and FIS, an open and cooperative working relationship, which I think is something all regulated entities in Guernsey will want to have with FIS. Thank you for your time. If you have any questions about what I've discussed today, if your company finds itself in one of the situations I have described, please do find me on our website and get in touch.